should start there. What do you think, Mike? Welcome.
I apologize. I didn't get the memo on the shirt. I mean,
Yeah, seriously, what are you doing?
I don't know if he has a shirt this color.
So actually, I think we should start there. And this is really where the video needed to start with. I wrote down a bunch of things that I wanted to go over, and it's essentially around, issues that we're seeing in closings. Just let's look at them. I wrote down a whole list of things, but it kind of starts with what you just mentioned, Dad, getting offended by something that the other side does. In your case, you were talking about a buyer election, and the seller was all put off because the buyer asked to have a tree cut down and whatever else the
Yeah, it was the
issues
other
might
way
be.
around. He was the buyer, and he was upset that the lawyer on the other side said these were
Cosmetic.
improper requests. Like he was a moral failure of some sort. And it's a high-end deal, so I gave him the whole lecture on how when you're dealing with people with that economic bracket, there's a certain etiquette involved. To give them nothing in a certain situation might come off as a offensive thing, and you might want to throw them a bone.
Well, you can't help attorneys from being attorneys, right? A lot of attorneys in town, they just don't see the whole picture. They can be a little blunt. In fact, I had a closing yesterday. The seller's attorney sent me an email and said, we would request that the buyer waive their financing contingency. It's a NABOR contract,
Right.
and the time period had lapsed. And so the attorney just reached out and said, we asked that the buyer waive their contingency. Perfectly reasonable. So I said, all right, let me ask. So I called the buyer and I say, hey, this is what the seller's attorney is wanting. And the buyer was, what is going on? Why do I have to waive it? And this is ridiculous. Is this fair? And I said, it's fine. He says, but I just talked with the seller. The seller knows that this deal is happening. I said, it's just the attorney being an attorney. They're fighting for their client. They're trying to remove contingencies so that it's more of a solid deal. They can, put together their future on knowing that there's less of an opportunity that the deal doesn't close.
Sometimes they're trying to score points for their client. Sometimes
Always.
It's always hard to figure out, is it the realtor? Is it the lawyer? Is it the client? Is it all of the above? Have you met the buyer or the seller in this case? So you can try to figure out who's making the demands.
Yeah.
But my favorite, there was a young attorney over Kevin Coleman's office, and he was asking for really ridiculous things from me. And at some point I just got ticked off and I stopped returning his phone calls. So Kevin called me and, why won't you talk to so-and-so? Well, I can't repeat the exact language I use, but as Kevin, he's acting like a jerk. That's the cleanup version. Tell him to clean up.
Yeah, I think and Mike, this is where I would love to have some of your input. Sometimes attorneys make the deals harder. Sometimes, too many cooks in the kitchen means that you're going to have a big mess of a dinner. Do you like attorneys, Mike?
It all
As your
depends.
counsel, the answer is yes.
Honestly, most attorneys that we work with, we've got a long history, and so you build trust, you build relationships, etc. But every now and then you see a deal where you have to separate the two attorneys and literally resolve the issue, and no one's wrong, and it's interesting. But no, by and large, I think Southwest Florida is very fortunate to have the attorneys that we have. I mean, they're
very diplomatic. I like it.
The absolute worst is having a litigating attorney doing a closing.
Don hit something earlier, though, that would be an interesting future topic, and that is the subject of trees. We've had more issues with trees through the years. Normally, it's a case of the tree going over the neighbor's fence. And it's, part of it's in their yard. Sometimes the issue is trees after a hurricane, whose responsibility. That actually would be an interesting topic.
Yeah, we've written about trees before, and it is a problem. I had two particular situations. One was a storm-related one, and it was the neighbor's tree. The storm hit, and it fell onto the other property, the next door property. And the question was, whose trees are those? And essentially, whose problem is this? Who has to pay for it? And there's actually case law on this. It basically, wherever it lands, that's whose problem it is. Unless the person whose property it was originally on, unless they knew that it was dying or was going to fall over. If they hadn't noticed that it was going to be a problem, then it would have been the original owner's problem. But just it falling, a perfectly healthy tree or with no notice, it's going to be wherever it lands. That's your problem.
You know, when I was a neighbor of both of you all down on Marco, remember, Don, when Hurricane Andrew came through?
Oh, God, yeah. We were up in my wife picked a place on the water in Tampa, believe it or not.
I found out the hard way that my insurance policy covered $250 in tree damage. And I had about a 10 grand bill just to carve up all the trees.
I remember one of our neighbors, the tree fell on the car. That was a fun one. But the other scenario that I ran into with a closing was that the neighbor had been asking to cut back trees forever. I mean, it'd been years. This neighbor wanted to cut these trees back. They thought it would open up the whole yard, but they weren't on the neighbor's property. They were on this client's property. And so she always said, no, I'm not allowing it, not going to happen, until the day before her closing to sell the property. And the day before closing, she gave the neighbor permission to cut down all the trees. Well, guess who wasn't so happy about that? I got 1,000 phone calls from the buyer, and the buyers were furious. It was like a $2 million property, and they're doing their walkthrough, and the neighbors cutting down like 20 trees, mature trees, right next to it. That was on their property. They were so angry, and obviously the seller did it to appease the neighbor, not realizing that she was going to have a major problem with her buyer. It was a real blind spot that hopefully no one will ever make that mistake again. Don't do that. Seller got herself sued over that. The buyers were furious. They didn't want the property anymore. It was a real mess. And I think the realtors that were involved, they got a pretty nasty gram on that one as well, because they were giving really bad advice. Oh yeah, it's your property. Do what you want. And yeah, sure, whatever. Terrible. Not a good idea. That's something that needs to be discussed and disclosed. You don't set your buyer up for failure on something like that.
Yeah, part of what they're buying are the trees. I mean, when my folks were buying their first house, my father showed up and the seller was removing a screw palm from the backyard. And my father's like, what are you doing? That's part of what we bought. That's an expensive tree. It's what they call a community tree. And the guy had to put it back.
Yeah, they call those champion trees.
Champion trees?
Yeah. So I wanted to go over some other items that we've run into recently and kind of get your guys' feedback on some of this stuff. Ultimately, we're looking at issues that keep coming up in closings time and time again. And this leads to, all the time people saying to us, man, there's no easy deals anymore. And I think it's true, but it's for a million different reasons. So it could be the trees, it could be something else. But one of the things we've seen a lot recently is bad paperwork, really bad paperwork. We're seeing where you've got missing information on deeds. You're just totally skipping over someone that was on title. You might be missing an affidavit of trust or a certificate of trust where someone was taking it out of the trust and they didn't record the certificate or the trust papers. The deed might be missing trust powers, but they were treating it almost like they were on there, which is a huge mistake. I even had where the grantee's name was missing on a deed. So that's a huge problem. I've had, in fact, in a family member, we had the trust name was spelled incorrectly. It was missing. I think it was completely wrong, actually. It wasn't even just misspelled. It was just completely wrong. And this is something that I dealt with this morning, an improper power of attorney. And so we've got a really big deal, and they were doing some estate planning. They had a power of attorney from 2017 from a different state. That power of attorney was used to sign a deed in 2020 to put the property into a trust. Okay. Fast forward to 2024, we're doing a sale and we pulled the title and we're like, wait a second, this power of attorney is improper. It is missing witnesses. That's not good. So
This is the Virginia one?
we're looking, so we look at this and we realize, oh, well, of course, it must be proper in Virginia, which maybe that will work. So we look at Virginia statutes. Again, we're not Virginia attorneys, but we
Right.
look at Virginia statutes, we see if they require 2 witnesses. It seems like they do. So now we just have this ineffective deed. The power of attorney is improper or invalid. And so what does that cause? It caused the seller to have to go through probate and still have to get a deed out of the trust, because the title insurance company wants no loose ends. Whether they don't want to be wrong about any of that. So they're going to have you do both now, all because of that POA. And I think the background on that is they didn't have a choice. They felt like they had to use that power of attorney because the person was incompetent or there was some health issues. So they did this, assumed all along that it was right and that was fine, and oh, we'll come back to it, we'll fix it later, and they forgot. And now the attorneys are playing catch up to try and fix everything. Here's one that actually came up yesterday. We closed a deal yesterday. The buyer took title in the name of a company name, but they spelled it wrong on the deed. In fact, they didn't just spell it wrong. They said it was a partnership, but in reality, it was a corporation. So the underwriter freaked out, like, wait a second, this isn't the same company. And it sounds so silly. The seller, and here's where the real problem I think exists. The seller said, well, the only thing in this company is the property. That's the only thing. This is not a big fancy corporation. There aren't 100 shareholders and a board of directors and all this stuff. He's like, it's just the 2 of us. And I said, but it's still a company. And you had it put on there as a partnership. It's very different. We've got a whole world out there where this name could exist in some other country, some other state, some other, wherever. So we had to dig into everything. We had to show tax returns, utilities. We had to get affidavits from neighbors. We had to get corporate charters. We had to get letters of good standing. We had to get their accountant from overseas to get involved. And all along, these sellers had to prepare for FIRPTA. And then in addition to FIRPTA, they have to prepare their tax returns in the US, which they hadn't done before. So this was something, it caused an incredible amount of anxiety in the sellers. And I think it really boils down to just a lack of due care, just not appreciating that the name matters. The deed matters. Double check the work of the attorney, double check the work of the realtor, the buyer, the seller. You can't just take it at their word. In fact, I've got a phone call I need to make later today. There's a listing that a listing agent is getting, and they said I don't know, I'm getting kind of mixed answers on who actually owns this property. So I look up the title. I try and pull in the title. Couple of things to look at. Let's see if I can show you on the camera here. Nope, that's the wrong one. There we go. So this is the tax assessor website. And what you'll notice, if we showed you on the video, like on the website itself, you would see this in color. But you've got different deeds here. These are the different deeds. Let's see, we've got one. The first deed was in 1999. The second deed was in 2005. The third deed was in 2005, and then another one in 2008. And sure, that seems confusing. What were they trying to do? So just to kind of get my bearings, I pulled the very first deed, and this is what it looks like. This is a problem. This is a problem.
They got that online.
Yeah. So Dad, you said yes. They pulled a form online and they did themselves. In fact, they wrote it out themselves. They handwritten it. They used an abbreviated legal description, which is, like what I would call a short legal, as opposed to the entire legal description. That's a problem potentially. And I think they had it coming out of 2 grantors and into a grantee, but I think one of them they used a power of attorney, but they didn't record the power of attorney. And this is almost 20 years old that they've been assuming was fine, everything was right. And this is just the most recent deed. I've got to go back 3 more deeds to see what other errors were included or what was missed. And if this was not a proper deed, I believe that the 2 grantors on this one have all passed away. So now we need probate on those 2 people. And we have to fix potentially some of the other stuff, plus get a deed out of this grantee, whether it was right or wrong. I need her to release any interest that may be out there. That's a mess. And so what I would recommend is when you look at some of this stuff, kind of have these red flags, issue spot, as I always say. Dad, did you ever use any acronyms in law school for issue spotting?
No, actually, no.
Wow, you got lucky. They have these acronyms. They're actually kind of nice. I like them because it keeps it simple. The one I always used was IRAC, IRAC, issue, rule, analysis, conclusion. I don't need to know the conclusion. I don't need to know all the rules. I just need to know if this is an issue.
Yeah.
That's all I need to know. Is this an issue? And then I'm going to call Mike, and Mike, you're going to solve it for me, right? So
I'll call
then you
you
have
Dad.
another deed. Let me compare that deed to another one. Again, we have our tax assessor website here. Let's see if
Can't
that
read
goes
that.
into Zoom or not. Hold on, just be patient.
Cheap
So now-
lens.
It'll get there. All right, so here are our new deeds. We've got 4 deeds. You'll notice 0 consideration on that most recent one. And
Can you
then
read
it
that?
had, anytime it's 0, that means it was probably an interfamily transfer. They put it into a trust, they added a spouse, they gave it to a child, something like that, you would see 0. So if I look at the most recent trust, the most recent deed, that is what a deed is supposed to look like. That's pretty sharp. That looks good. Let's see if it zooms in at all.
Is this
Maybe
one we
not.
did?
I
Hopefully.
know it'll get there. It'll get there. So this one was drafted by an attorney. It has the full legal description. It has trust powers on it. In fact, it lists who the trustees are. And then it lists a separate person on top of that. Our legal description is down here. I guess you can't see it that easily.
Yeah.
And it's witnessed, it's notarized. Everything has been recorded with that deed. And not only was this one done by an attorney, then it seems to have everything in it, but all the previous transactions were for consideration. They actually they paid money. There was probably title insurance. There were people involved. There might even been realtors involved. And so I would probably say I don't see a big issue there. That seems pretty straightforward. That being said, it is in a trust. And so, I'm going to want to know, are the trustees still living? If not, let's see the trust powers. And then your broker, Mike, may ask for a little bit more before they list a property like that. Mike, what is your typical process for reviewing a listing? How does that typically go?
Actually, you're asking the wrong one. Pat Patoka handles all that now, but where we've been wrestling with it a bit is when the property is owned by a trust, to be honest. I mean, it's Don and I have had numerous discussions on this, and that's the one, with all the fake sellers that are happening in this area, you really have to be careful in these listings now. I mean, it really.
Yeah, well, you do, and I think the whole adage that, well, that's someone else's problem, I think that is not okay. I think we all have to, realize that we have to be issue spotters. And so if we see something, you should try and get a second opinion, get some sort of feedback and say, hey, I talked with our attorney, I talked with our broker, we went this route. And it's not pretending that you know the answer. It's just saying, hey, I wonder if this is okay. This doesn't seem normal. I don't just see husband and wife on here. It looks like there are kids and grandkids and the parents, and they may have passed away. You start to feel like, what else is going on here? So that I think that's really great.
Well, if you think about it, as realtors, we're starting to work with artificial intelligence. Well, so are the scam artists. So it's going to get scarier.
Well, Mike, that's a perfect transition, because the other thing I wanted to do was kind of looking at some of these illegal deeds, forgeries, fraud, things that are really freaking all of us out. And so I actually had a deal when I was up in Georgia where the son pretended he was the dad. You know, the deed did not do a good enough job distinguishing who the actual owner was, because they both had the same name. One was, senior, and one was junior, and it didn't distinguish that on the deed. So when the title company, reviewed it, seemingly, they couldn't distinguish. They were like, oh, well, this is the guy, he has the key. Well, that was the son who was living there, but it wasn't his house, it was his parents' house. So very tricky. I would say if you have something like that, you need to distinguish better. You need to state that it is senior versus junior, or you need to distinguish a middle name, the third, the fourth. In fact, what we do with LLCs or corporations is we'll specify what state or country they were formed in. So we'll say, Ross Title Inc., a Florida corporation. We'll say something like that, as opposed to just leaving it Ross Title Inc. I want to distinguish exactly. And I think this is things where, you guys as realtors, you're so involved with your clients and you're trying to give, full service. I think you can catch on to those sorts of things like, hey, let's look at the deed. Let's make sure it's in your names. I know you always wanted to put it in your LLC, or I know you were going to put this into the trust. Did you follow up with that? Has that been done? I think looking at that stuff is really helpful. And then to other types of scans, which are almost a little bit more prevalent, those seller impersonations. Mike, that doesn't happen in your office, does it?
Well, it's kind of ironic because as realtors, we're excited about using technology, yet the scam artists are using technology against us.
Yeah.
And a lot of times the scam artist doesn't want to meet with you. They hide behind text messages and emails. They might call from a burner phone. So, you have technology cuts both ways, unfortunately.
Yeah, so I think you just have to have your layers. And so this is an example of some of the layers that we've instituted in our office. This is a technology called IntelliCheck. Basically, I'll put in Mike's phone number. See, we'll just put in 001, capture his face, see if he's on a watch list, and then we'll text him the link. Type. Doesn't your number start with 666, Mike? I think that's what it is. So you would get a text message, and you would have to scan your driver's license. It would take a picture of your face, and it would actually determine, watch list, not watch list. Are you on the no-fly list? What databases have they searched? It's really wonderful. And we do this every chance we get with our clients, just to give them the assurance that we're not just doing it for them, we're doing it for everybody. Also, we've always used certified. I'm a big proponent of certified. Just went to one of their conferences in Texas. I think they're the forefront of this intelligent verification. I would say it's similar to the technology when you apply for a credit card, where it asks, did you ever live on this street? What kind of car did you own? Do you know this person? That sort of stuff. And it verifies that together with, where are you inputting this from? Are they, is there a real person behind there, or does it seem to be automated? Or do you have some sort of geo blocker, where they can't track where your IP address is from? So it's really, really kind of cool. And they've got all the different sources. In fact, we just got asked to be a beta tester for certified on a seller impersonation or identity verification thing. And I think that'll be really cool. We'll see if we can get every law firm and title company to use it, because honestly, it really works best when everyone's on the same page.
Is there insurance for this, Christian?
What'd you say?
Is there insurance like they have for the buyer?
Oh yeah. I mean, it insures every transaction up to $1 million. And knowing that they're involved, even if the deal is more than $1 million, you know that they're on the hook, you know that they're doing the work, and you've raised the bar. You trying to make it a little bit better.
Yeah, nobody can argue you didn't up the standard of care.
That's right, standard of care, and just trying to make sure we're better than we absolutely had to, but not stopping. We don't want any sort of limitation on what we try to do. The other thing we do is more manual. One, we make phone calls. We love to talk to the clients. We always make sure that we introduce ourselves, and we kind of have this pit in our stomach if something doesn't smell right. Separately, we send a letter, and Mike, your office has started doing this as well. Anytime we get
caught a scam last week doing that.
Did you really? Can you tell us about it?
Just sent a letter to the real owner, and they said, no, we didn't list with you.
So
fortunately,
where did you get their
forwarded it.
address? Where did you find all that?
Pat handled it. You'd really have to ask her, but we started sending a letter to the owner, and sure enough, and I had heard of one of our friendly competitors doing the same thing, and it works. You kind of hope you don't see it, but it does happen.
Yeah, exactly. So what we typically do is we pull up on the tax records. So we'll look on the tax records and we'll see exactly where the forwarding address is. So we don't send it to the property address, we send it to the forwarding address that's listed on the tax records. And it works really well. Let me see if I can find you an example. First one I found, it was one in the same. So what these scammers will do is they'll look, yeah, here we go. I got an example for us. They'll find a property like this one. This is seemingly on Marco Island, and they'll show, this is the Marco Island address here at the top, but this is their forwarding address. They're not the same. They're seemingly from Indiana, or at least they're sharing their information back to Indiana, back tax bills and notices and things of that nature. So we'll pull that address, and that's where we'll mail it to. And the letter essentially says, we were hired by you to sell your property. If this isn't correct, please call us immediately and let us know. And we've caught a couple of scams that way. Is that very hands-on, simple process. We had another deal where, and this is where it takes some chutzpah, I think, if I'm using the word correctly, but you have to be willing to say no. If you're not willing to say no, then you're going to fall for these scams. You just are. There's no other way to avoid it. If you are so desperate for the closing or for the listing, you're a real risk to everyone involved.
I mean, there's a delicate way of saying no, Christian. The last one we had, the guy was in Georgia, and well, it wasn't the last one we had.
No, we had one last week as well.
Yeah, but he was located in Georgia, but he was from someplace else. And I told him that your former office was there, and he could go sign there, trying to verify his identity. And when he didn't like that idea, I told him he was on a fraud alert for my underwriter, so we need to have some verification. So it's not me being the bad guy; it's our underwriters requiring it.
Yeah, I think
which does happen actually.
Here's how I see it for realtors, because I've seen a couple of messages in our comments here. One question was, is there any tech you recommend for realtors? And another realtor said that she actually calls several lot owners with fraudsters that are selling their lot. She's kind of doing a service to the community in that sense. Right. And I think it's good for business. I had 2 or 3 realtors who were pretty on top of it, and they alerted the true owners, and the true owners then hired them to list the property. And because they were like, oh my gosh, how do we repay you? You saved our butt. And it's like, well, are you ever interested in selling? And at that point, they're so upset, they almost don't want it anymore. They're like, I can't let this risk happen to me again. Let's just get rid of it. And it can be a really neat opportunity if you are diligent about it being right. I've had a couple of realtors, unfortunately, that go the other way. They're ignorant by choice. They don't want to know. It's their buyer and it's not their problem, and they assume the listing agent did the work. I think there are title companies that act that way when a seller is represented by a lawyer, by someone separate. They're like, oh, well, they've obviously verified separately, but I think we're smart enough to know that you can't trust that anyone else did it the right way. You have to
I
do
mean,
it yourself.
huge red flag is if the closing is real fast and it's greatly undervalued. I mean,
Greatly undervalued, real fast. Seller, the listing agent isn't really relevant, doesn't really make a lot of sense why that realtor's involved. Like, for example, if you work a lot in on Marco Island and someone calls you for a Bonita listing, an empty lot in Bonita, you kind of have a problem. I don't think that makes a lot of sense.
That's a red flag right there.
That's a red flag right there. Exactly. As far as technology for realtors, I think the letter is the simplest way to start. You got to send a letter. If you're willing to list a property and take pictures and put in all this work, just put a simple letter into the mail. You're welcome to call me. I'll give you the wording that you want to put in, but it needs to be simple. You know, thank you for hiring me to list your property. If that is not accurate, please call me immediately.
It's sort of like we're doing now, Christian. We use the technology and we do it the old-fashioned way. We're hitting it from both sides.
You have to do both sides. The other thing is, I don't ask for driver's licenses anymore, at least not on the front end. That's not how I verify because they can be faked so easily. I want a copy of the closing statement. I want their title policy. I might want to meet with them in person. I want it to make sense. You know, I kind of want it to be a normal thing. You know, we used to sell, my wife and I used to sell things on Craigslist or buy things on Craigslist. And you kind of get a feeling for when it's scammy versus when it's normal. Normal is what you should expect. Anything scammy, anything too easy, too weird, you have to be willing to just ignore it and blow it off. Here were some other wild stories. Recently, I had a couple where we didn't have all the owners on the listing. And these were things that one of them could have been avoided. The other one, no one knew until it was too late. So the one that was too late, they on the deed from the 1980s, so as old as me, it actually said these two people as joint tenants. Unfortunately, that's not right. So what they were hoping to accomplish was that there would be rights of survivorship. So if one of them passed away, the surviving person would receive the whole property, would be automatic. So that's joint tenants with right of survivorship. But they only put joint tenants, and that's not good enough. So fast forward almost 40 years, and they do a closing, the title comes back, and everyone realizes, oh, we have a major problem. We have to go find this other person's family. Did they go through probate? Who are their heirs? Who's still alive and who's not? And it's a mess. This one got so out of hand. In fact, we ended up having to send a letter to this estranged person in their family who they hadn't talked with in 40 years. And we had to send a letter saying, we are trying to contact you. We need your help to sign some papers. You know, so-and-so is trying to sell the property. And this person called me back. It took a week or two for them to reach out, and they said, I've been waiting for this phone call for 40 years. That's a problem.
Payback's tough,
You know, not to be the judge or jury in deciding who deserves what, but it seemed obvious to me that this estranged family member was now out for money. You know, they've been estranged for so long, but now they're back because they see blood in the water. Pretty nasty, pretty ugly.
Did an out-of-state lawyer do that deed, Christian? Do you know? Remember?
What'd you say?
Did an out-of-state lawyer do that deed? Because I see that contributing to the problem.
No, it was I think it was the trust company that did that deed. They just, you know, things are a lot different in the early 80s than they are now. You know, it's been 40 years. The technology, I mean, back in the early 80s, they didn't have computers so much. It was probably typewriter and forms that they would fill out. And if they made a mistake, no one knew. No one knew until you go to sell.
Part of the problem always has been that people think it's simple and it's really not. There's a lot of nuance in a one-page document.
Yeah, there's nuance.
That's why they'll use a form. They'll
you know what part is simple? The part that's simple is being able to mess it up.
Yeah.
That's pretty easy. It is a straightforward form. It should be easier. You know, but it's not like a database where you can just put the information in, fill out the form and be done. It has to have the proper information, and it's not just the deed that matters, it's all the deeds that come before it that
Yeah, there's
matter as well.
some check boxes that on that one-page document that have to be checked off.
Yeah, exactly. So that one was pretty ugly. They're actually in court over that. They're going to figure out who owes what, who deserves what. They've got all these different legal arguments, but ultimately, because of that small mistake, 40 years later, it's probably going to cost them hundreds of thousands of dollars to resolve, if not more. Separately, we have life estates. There are a lot of people that want life estates. And we have a life estate that was created. You know, a lot of times we have these mixed marriages. You know, maybe it's a second marriage and they're kids from different marriages. So the spouse, you know, wants to allow for, you know, taking care of his wife or the husband after they pass away. So they give the spouse a life estate and then to the kids. And which is fine, that works great unless they don't understand it. So in my scenario, the widower or the widow decided to sell. She's like, I've had this forever, I'm ready to sell, I need the money for X, Y, and Z. Well, she only had a life estate. It was the kids that had the remainder. And so she goes to list the property, she finds a buyer, and they get to the closing and they say, well, where are the other 4 kids? And she goes, what do you mean? This is my property. No, not yet. Not entirely. You have the right to possess it. You have the right to use it and to, you know, profit off of it. But if you were to pass away, it goes automatically to the children. It was not an enhanced life estate. They needed the children to approve.
This is the second wife, Christian?
Yes, yeah, exactly.
So typically they want the property to go to the kids of the first marriage because their spouse died. So there's a lot of that.
Exactly. So that's pretty ugly. And I think in that scenario, you know, if you pull the deed, if you're the listing agent, you looked at the deed and you downloaded it, the tax assessor website's not going to show the remainder children. It's just not going to. But when you look at the deed, you'll see that it's only a life estate. And if you see that word life estate, that should be a red flag. Red flag, red flag. We got a problem. We got to get these other kids involved, or maybe we don't. If you don't, that'd be great too. You probably need someone to look at it and double check. And that's what all the brokers are trying to accomplish. They're trying to make sure they have their ducks in a row. You know, here's the big one: inspection issues. There are no inspection issues, right, Dad?
That's what I was doing this morning.
Yeah, I mean, it's like every phone call is an inspection issue, and it really boils down to the simple stuff:
Deeply offended.
Cosmetic versus defect, or, you know, is it working condition or not? It's brutal. It's brutal.
Hey, why won't they, you know, replace the screen?
So I'll give you a couple of examples. You know, in this video series, we've actually discussed the double pane or triple pane windows that have like the gas on the inside. And when that seal breaks, you'll see the windows will fog up pretty easily. And it obviously, you know, the window is not performing the way that it was initially intended. That being said, the contracts don't always spell it out whether that's a defect. You know, I think I could easily argue one way or the other that it's defective. I would personally like to see the contracts more specific that it is a defect, but all it says about windows is that they are watertight and structurally sound. I think that's all it says. Like, do they keep the water out? And a broken seal for that gas it might be okay. It might be. I don't know. It might be. But other examples, ones that I've seen recently, cracked stucco. Dad, do you think cracked stucco is a defect or cosmetic?
I actually had this with my dad's last house. It was cracked. It appeared to be cosmetic. After he closed, he found out it was not cosmetic after he did a core testing, which you're not allowed to do under this contract, and found out there was 7 yards of missing soil underneath the pool deck. So it could be something that's not in working condition if it's a structural issue like rebarb or something like that. But there's no way to really tell because then you're not
Yeah,
allowed to do
exactly.
it.
And that's, I think you nailed it. The other way I was thinking about it is you have a big crack in your stucco. The defective, it would be defective if it is not watertight and structurally sound. So if these are hairline cracks through the stucco, basically just a coat of paint would be fine. I think that's cosmetic. But if it's a major crack that and let's say it's even like a wood framing, that doesn't sound watertight to me. It sounds like you could have water getting in there. We had a closing where the siding along the front door had cracked. There was a big slit. And if it was small, if it was hairline, I could see how that's cosmetic. We're not gonna do anything on that. But this was a big slit right into the siding, and definitely water could get in there. And if water's getting in there, it's going to compromise the whole frame of that doorway, and potentially you already have some wood rot, but it's hard to determine that. If the other thing that inspectors will look at is whether it is wet on the inside or not. But if you're not in rainy season, you may not know. It could have been dry for months. It's really hard to tell, but you have to go back to the contract and look at the paragraph that talks about whether it's structurally sound or not. Mike, I'll give you an example if you'll play along with me. This is a dock on the water. There's like a boat dock. And boat docks are, they're in working condition if they are structurally sound and free from wood rot. They have to be free from wood rot. So we have a dock and it's wood. And there's a board, just one board. So let's say it's this board, but like part of it is cut off. Like it's almost like it's withered away and fallen off, but the rest of the board's fine. Is that defective?
This is where you set me up.
Yeah, totally.
My gut tells me, yes, it is defective. Particularly if it's a hazard where someone could trip or fall through.
I think you nailed it. So you didn't know it, but you nailed it. If it was a hazard, then it is not structurally sound. And Dad, you're gonna have an opinion about it too. But in this scenario, the question I asked, the follow-up question was, is it safe? And the homeowner said, well, I wouldn't walk on it because the boards are all moving around, they're loose. And there's a big piece, and if my granddaughter came in and sat there, her foot would fall right through. That's not structurally sound. That is a defect every day of the week. Now, if it was a small little piece, if there's a crack in the board, those boards don't have to be watertight. That is not the same for siding, but for the dock, it just has to be structurally sound and free from wood rot.
The gentleman I met with this morning, there's 2 points, and I went over with him, and I typically go over this with anybody. I always look at the deposit, how big is it, and how much does it cost to repair the contested defect, whether it's working condition or cosmetic. If it's something you can argue about, and your deposit is $100,000, and it's only $2,000 to fix, say, this wood dock, are you going to gamble the $100,000 to gain $2,000? And so just looking at it from financial perspective, you got to bring that in so they can put it in proportion, and is it a risk worth taking? The second point, something might not be a defect under the contract, like an open permit. There's statutes that can't be enforced against the buyer and all that stuff. Well, there's legal risk potentially if it has anything to do with wiring. The buyer is on notice that there's a wiring issue. So if somebody comes along and gets electrocuted, that would be a good negligence lawsuit against the homeowner, not to mention the moral dilemma of having to live with the loss of a human life. You don't want that. And that's happened on Isle of Capri. So I've seen that happen.
I'm glad you brought up permits, because permits are something that I see people make a mistake on all the time. Share my screen one more time.
Yeah, you got one election and they forget. So they do it later.
And you see the buyer election?
Yep.
Yeah.
Yes. Okay. So notice on this one, most people know enough to select this list of systems and equipment, check the box, everything that's on the inspection report, throw it in there, on the separate page. That is fine. Same thing with radon, termites or wood destroying organisms, toxic or pathogenic mold. This one here, I see people make a mistake on this every day of the week. You have to add this in if you know that they're unpermitted work or open or expired permits. So I'm not sure how every office handles it, but with our office, we will do a permit search on every closing. And we will send an email to the agent and say, here, if there is an open permit or there is an expired permit, here you go. Now, if you don't hear from us, there probably isn't one, but you should double check and say, hey, I didn't hear from you. But if there's an open permit, we send it to you for one reason. You have to add it onto your list. If you don't add it onto the list, then the seller may not agree to fix it. Alternatively, the other thing we would do is we send it to the seller's attorney. And we just forward it to the seller's attorney and say, hey, just so you know, there is an open permit, and we are asking that the seller repair it or remediate it. But that doesn't mean the seller has agreed to do it. You need to add it on the list so that when the seller later on says, accept, now I can obligate the seller to fixing that open permit or that expired permit. And that is so important. Dad, you and I have a big closing on Monday. And luckily, the agent was smart enough, took that information, put it on this buyer election form. And now, if the seller doesn't get it fixed, now we can require an escrow. We can put 200% into escrow. But without it, we're dead in the water. We're leaning on the seller's good graces to make this happen. That usually only gets you so far.
Another glitch, Christian, that I see quite a bit is the agent asks for, this open permit to be closed or whatever it is to be fixed. We ask for it to be fixed. They send it to the other realtor, the other lawyer, and you assume they're working on it, but there's never an email back saying we agree to fix it.
That's what I was referring to. It has to be on this list.
They're trying to trick you into letting the 10 days run and the other 5 days after that, so they're not obligated.
Yeah, and that's why I want it on the list, because if we just send it to the attorney and we never hear back, we're probably going to miss our ability to terminate. We've got to make sure that that is in there. Absolutely. The last thing I wanted to talk about, and you're going to hear more from our office about this in the coming months, but there is a FinCEN, Financial Central Reporting System. It's through the Treasury Department. I just botched the name, but we refer to it as FinCEN. Couple of things going on. Number one, you'll notice that FinCEN reporting requirements have been added into your NABOR and FAR-BAR and FAR contracts. So it is something in there that talks about the requirement for buyer entities to be reported to the Treasury Department. And that is being expanded. So every deal that you do from next month on, if it's an all-cash deal, FinCEN reporting will be required to who the buyer is. And it's the federal government basically wanting to know who is paying all cash for this real estate. Who is?
I read trying to modify that, Christian, because all the mom and pop places could theoretically, it's like 500.
That's different. That's the other side of it. On this side, this is closings. And it's every cash deal, trust, individual buyer, corporation, partnership, whatever it is. Right now, we have to do it for corporations, companies, and partnerships. But come June or July, it's going to open up to everybody. Everybody's going to have to go through this if they're going to buy a piece of real estate in all cash. Now, they don't make you do it if you're getting a loan. And I believe the reason is because you're working with an institutional lender that is going to be reporting it separately. That they verified who the owners are or who the buyer is. They verified their citizenship and their social security numbers. And so they're kind of trusting that that's not as much of a risk. Now, separately, the piece that you're referring to, Dad, there is a law right now that says every business owner is going to have to report their beneficial owners. Every single person that owns a company or a corporation or partnership is going to have to report that. And that is due by the end of the year. So there's going to be more information coming out from us on that. If you hear anything in the news or from an accountant or an attorney, just realize, yes, it is very real. That is happening. There's some there's some talk about possibly getting it removed or delayed somehow. The way I've seen FinCEN used and everything else, I don't see that happening. I think it's just going to come through like a train and
I
everything.
don't know the answer to this, Christian. Maybe you do. I mean, what about layered corporations? If it's a Florida corp that's owned by a Dutch corp that's owned by a Liechtenstein, Anstalt, I mean,
Yeah, it all has to be reported.
But how are they going to know? I mean,
They
Liechtenstein.
well, they fine if you don't report the beneficial owners. There's a $500
That's a
a day
$500
penalty.
a day. And that's the one they're working on, like for the mom and pop places
That's one they're trying to fight as being unconstitutional. But FinCEN has been around for decades. This is not new. It is not, it's been tried before. It's going to pass through. It's already on the books. It's already a requirement. I don't see it going away. Maybe the politicians, kind of slim it back down a little bit, but it's not going away. That would be.
And I see a real huge problem with that because so many Europeans, they invest money that they didn't declare tax on to their own home country. And they'll go to tax havens where it's bearer shares or numbered accounts. And they're going to lie. Or they're going to come up with somebody who's a front.
They might lie, but don't lie. That's bad, right?
Well, we're not going to get the truth from our clients. Surprise, surprise. But
well, that is the reality that if you're a bad actor, you're going to lie, and if you're not, you're going to tell all the owners on who that is. We'll see how accurate the data is. But if from my companies, I've already filed. Right, so everything's already out there, who the beneficial owners are and everything like that, because that's fine. That's fine. Okay with me. I'm already filing tax returns as to who the owners are. So what do I care? That's fine by me. Someone asked, are you saying there's a new NABOR contract or one coming soon? Yvette, there actually was an update last year, a slight update. It had that FinCEN reporting requirements added and maybe one or two other things. There's absolutely updated NABOR contracts coming in 2024 it is a change year anyways for NABOR contracts, so you'll see it, but they're trying to respond to the NAR settlement and some of the other things that we're trying to fix.
The surf be in there, this one, isn't it?
Everything's going to be in there. It's quite extensive, but the core of the contracts I don't think is changing very much. You're not gonna see new names and new remedies, and that stuff is not really changing. It's just trying to make it better, trying to respond to the the condo statutes that have updated and to respond to the NAR settlement requirements there. So we shall see exactly. I don't know timing on that. I would guess in the fall is when you would see things, but they're working on it at the moment. Well, thank you both. That was a good one for not knowing exactly what I wanted to talk about. I had a lot of things.
Yeah, surprise.
Thank you, Mike.
All right, enjoy it. Take care.